Good afternoon and welcome to WG University, Weber Gallagher's series of educational programs. This is our employment webinar series. I'm Julie Kinkoff and I am presenting today with Jennifer Laver, and we are in our Philadelphia office. Today we are pleased to bring you this special presentation about the conundrum that we're asked most about probably, solving the ADA, FMLA, and workers' compensation conundrum. If you would like to view this webinar again, share it with others, or see other WG University programs, you can go to Weber Gallagher's website, which is www.wglaw.com, and you will find copies of this presentation and others under the WG University page. Also, feel free to contact the firm with any questions at questions@wglaw.com. So let's get started. Hi, Jennifer.
Hi.
Okay, so what we're going to talk about today is our agenda is really to talk about how the different statutes fit together. We're going to talk about the FMLA, the ADA, and the New Jersey equivalent, the New Jersey law against discrimination, workers' compensation, and state disability.
So we're going to start today just talking about the interplay between the Workers' Comp Act and other laws. Just so you know, compensable injuries may give rise to issues such as the nature and extent of an injury, the extent of disability resulting from the injury, reasonableness and necessity of the medical treatment. A lot of times there's extended absences from work, or you need to modify the jobs in order to return to work. So we're just going to talk about how that intersects with Workers' Comp Act, FMLA, ADA, and those types of issues.
So where does the conundrum come in? Well, when you have an employee who's out on workers' compensation, and you also need to figure out if they are maybe entitled to relief under the FMLA or the ADA or the NJ and does that employee have to ask for FMLA, or do they have to ask for a reasonable accommodation under the disability statutes? We'll also talk about what happens when an employee who is on workers' compensation is released to work, but is released to work with restrictions.
Additional issues we're going to talk about is, can a light duty program be exclusively for employees injured on the job? What if the employee exhausts the is still on workers' comp, but then exhausts their FMLA leave and is still not released to return to work? And then what constitutes an undue burden? So the first issue is what is obviously the Workers' Compensation Act. So the Workers' Compensation Act is intended to provide relief to those injured on the job. It's a form of insurance that provides financial assistance, medical care, and other benefits for employees who are injured on the job.
And we should say that today we're focusing on the New Jersey Workers' Compensation Act,
Correct.
Right? And do they differ by states, Jennifer?
Yes, they do. Each different state has different rules and regulations, and what the carriers are permitted to do, whether medical treatment is authorized by the carrier, or if they can go out and seek treatment on their own with whoever they want. In New Jersey, it's a little bit different in that the carriers get to control the treatment, which in my opinion is a beneficial thing. So you can sort of control the medical treatment and the return to work a little bit quicker.
Right. I would also offer that I know that on the website, on the WG University website, we do have a discussion that relates more to the Pennsylvania Workers' Compensation Act, so that if
Correct.
you are if you're more focused in Pennsylvania, or you have a Pennsylvania question, you can look there.
Correct.
As well.
So the first issue we have is who's covered by workers' compensation. The law requires that all employers not covered under federal law to have these protections. You have to have workers' compensation. There's no exception. Keep in mind this can include out-of-state employers where the contract of hire was made in New Jersey or work was performed in New Jersey. And these are for employees who suffer job-related injuries or illnesses, or the death benefits to dependents of workers who have died as a result of their employment. Keep in mind that this relationship, an employee-employer relationship, is liberally interpreted, so it's not the same as what the Internal Revenue or the unemployment compensation statute. So you have to keep in mind that just because someone doesn't think that they are an employee of yours, they may actually be. So it's really important to ask those questions first, and when you have an accident on the job, if you're not sure, to contact us or to contact your carrier to just confirm whether or not they're actually an employee of yours.
And also, it does become an issue a lot of times with employers wanting to classify people as independent contractors versus
Correct.
employees to avoid, different taxes and stuff. Each state has its own tests. New Jersey's
Correct.
test is pretty stringent.
Mhm.
And if you have any questions about that, we can always help you with those.
Absolutely. New Jersey, unlike many of the other states, provides what's called New Jersey State Temporary Disability Insurance. So this is a program that's afforded to New Jersey employees. So keep in mind you must work in New Jersey. So just because you live in New Jersey doesn't mean you get it. Covered employers are those who employ one or more individuals and pay wages of $1,000 or more in a calendar year. Employees to qualify must have had at least 20 base weeks where they earn $168 per week or more, and or $8,400 over the base year, which is the 52 weeks immediately preceding the week. This is something that for New Jersey temporary disability insurance, going on to the next slide, an employee can apply for this even if it's a workers' compensation claim. The key is normally if it's an accepted workers' compensation claim, they would be entitled to temporary disability benefits through the carrier. However, in a contested claim where it's denied and they're not working and they're not getting temporary disability benefits, many times the employee will apply for New Jersey State TDI and then a lien is placed on the claim. In order to be eligible, the employee must meet all the requirements under TDI, and they must file a formal CP. On the formal CP, when they do that, the signature for the TDB application specifically states that if it's a workers' comp claim that you must file this. And keep in mind that unlike many other liens, this is not something they do not negotiate. It's very, very difficult for you to get it to be removed. Generally, it would take a complete trial where the judge finds that this is not a workers' comp accident for the TDBI lien obviously to go away because the case is then dismissed. But it's really, really difficult for you to get this to go away once it's on a case, and it must be considered as part of the settlement.
Okay. And the federal law that relates to medical leave is the Family and Medical Leave Act, the FMLA. It is intended to allow employees with a serious health condition time to care for themselves or also time to care for their family members. Most workers' compensation injuries are going to qualify as a serious health condition under the FMLA. But not all serious health conditions under the FMLA are also going to qualify as a disability under the ADA. It's a different type of test, and it's one that needs to be run separately.
Correct.
So under the FMLA, what do employers have to do, and what do employees get? Employees get 12 weeks of unpaid leave. That leave can be intermittent, and anybody who has had to manage an intermittent FMLA leaves know that they can be a real pain, and they are very difficult a lot of times to work with.
And keep in mind that even you want to consider intermittent FMLA leave if you have an employee who isn't out of work completely, but has to go to attend doctor's appointments or physical therapy during work. You still would want to categorize it as FMLA leave and use that intermittent leave policy for those types of treatment issues.
Right, because you want those issues to be counting towards those 12 weeks.
Exactly.
Yeah, the FMLA also requires that the employer continue benefits. That's the insurance benefits, health insurance. Time that is taken for FMLA leave cannot be counted towards no-fault attendance policies. The FMLA, unlike a lot of other kind of civil rights type statutes or employment statutes, specifically includes in its language claims for interference, which means that if a employee could have a legal claim against the employer if they feel that the employer has interfered with their leave. There also is provisions that prohibit retaliation, which are in all of the employment statutes.
FMLA leave for compensable work injury, what you want to keep in mind is that when you know someone has an accident and they're either, as we discussed, the intermittent leave, or if they're out of work completely, you want to make sure that you run this leave concurrent. So the second that they advise that they're out of work or that the carrier advises that they're out of work, you want to indicate to them that they are going to be using their FMLA leave as well, and that it's going to be concurrent with that, and it's going to count against that leave. But you want to make sure that you do that because you have to notify them that you're planning on doing that in advance of starting that. So as soon as you realize that they're going to be out for a period of time or they're going to be on intermittent leave, you want to get that started. Keep in mind that your employee handbook should have this stated in there, that it's going to run concurrent, and just make sure that it's something that you do. It's one of the things that we hear most often that's forgotten by the employers, that they just assume that because it's workers' comp, they don't realize that the HR and the people handling the workers' comp have to actually talk to each other and have these discussions.
Right, and FMLA, in order for that to come into play and for the time to count towards those 12 weeks, you have to make a designation notice and you have to prepare the FMLA paperwork within the time frame set forth in the statute and the regulations.
Exactly.
The other piece of this kind of trifecta is the Americans with Disabilities Act. Now, the Americans with Disabilities Act is the federal statute that is intended to protect people, disabled individuals. It's going to apply to physical or mental impairments that substantially limits one or more major life activities. So this can be either, under the ADA, it could be an actual disability, it could be a perceived disability, or it could be a record of a disability. So a record of a disability is if you have one thing that the statute or the regulations say is a disability is cancer. So if you have an employee who has a history of cancer, even if it's in remission, they would have a record of a disability. Now that's not something that may come into play with the workers' compensation aspect of things, but it's something to keep in mind in terms of the ADA, that it can be either an actual perceived or a record of a disability. The ADA requires that you provide reasonable accommodations to employees as they need them, and it also prohibits discrimination, and it also prohibits retaliation.
And as we said before, just because they have a workers' compensation injury doesn't necessarily mean that they have an ADA disability. Not everyone with an injury has a disability, and so under workman's comp, an injury and wage loss gives you disability. Under the ADA, actual or perceived physical or mental impairment, regardless of whether it was a work-related injury or if there's any wage loss, is the standard. So you have to keep in mind there is a difference between the two.
Okay, so a reasonable accommodation under the ADA, and also the same thing is required under the NJ we should say, under the state statute in New Jersey.
Right.
Employers have to make reasonable accommodations to qualified individuals with disabilities unless doing so poses an undue hardship or a direct threat. So when doing this and going through this analysis, first of all, if you're going to rely on the undue hardship or direct threat, first call an attorney, because they are both very difficult to rely upon. The real question is going to focus on what are the essential functions of the job. The job that this person is hired to do, what are the essential functions as opposed to like the periphery functions. And also you may need to restructure the job, reallocate or reassign marginal or peripheral functions, modify their work schedule, modify work equipment, maybe they need a different chair, maybe they need, a different type of keyboard, something like that. Another type of reasonable accommodation can be unpaid leave, but that is not indefinite, and I know we are going to talk about that some more later, so we'll postpone that a little bit more. The interactive process. So the interactive process is required under the ADA and the NJ Failure to engage in the interactive process can lead to liability. So what happens during the interactive process? The employer and the employee need to participate in good faith. This enables the employer to obtain relevant information to determine whether the accommodation is feasible, right? Whether it's reasonable under the circumstances, whether it could cause an undue hardship or a direct threat.
And one of the reasons that we say you may want to consult legal counsel is just because you want to make sure that you document everything, that you have everything that's necessary under the law that gives you the best protection. So keeping in mind whatever communication you have, that it's not only just verbal communication, but all the discussions are backed up in correspondence confirming what was discussed and what was told.
Yeah. I would also add, when it comes to the interactive process, particularly under the ADA, there are a lot of great online resources. There is a JAN, Job Accommodation Network, I believe is what it stands for. But that's one that talks about, particular types of medical conditions and some suggestions of accommodations that might be considered. Not necessarily required, it's not a regulation, but it can be a good resource. And it also kind of shows a little bit of what's not what's a little bit too far as far as a requested accommodation. You do not have to provide the accommodation that the employee requests,
Correct.
right? Just because they ask for it doesn't mean you have to provide it, but you do have to go into that interactive process.
And you could always offer an alternative that's a little bit more reasonable given whatever the job is or whatever your restrictions are.
Exactly. Okay, so the law against discrimination. This is the New Jersey statute. It's very similar to the federal statute, except it doesn't use the word disability. It uses the word handicap. It is broader. The definition of disability is broader under the state statute than it is under the federal statute. Virtually any physical or mental impairment, without regard to whether it substantially limits a major activity, is going to be considered a handicap under the New Jersey statute, where it may not be considered a disability under the Americans with Disabilities Act. So if you are in New Jersey, it is definitely something else that you need to look at. The requirements for a reasonable accommodation are essentially the same. The defenses for impose of an undue hardship are the same and are, also hard, very hard to use as an excuse. So if that's a road you're considering going down, talk to counsel.
It's important to keep in mind that New Jersey is very, very employee friendly. So they're going to try and do anything to help the employee out. So just when evaluating all of these issues, just keep that in mind. Which is why we generally recommend that you consult with an attorney if you're not sure. It better protects you and better prevents litigation.
Yeah, the other thing that I would add, that one of the differences in New Jersey as opposed to many of the other states is that an employee can go straight to court.
Correct.
In New Jersey under the NJ. They do not have to go through the administrative process of the EEOC or anything like that. So those state court claims can go straight to court and can get real serious real fast.
Exactly. So we're going to talk about transitional or light duty. Just keep in mind that employers never required to reallocate essential function of a job under the ADA. Employers never required to create a new job either. But you can choose to create a temporary light duty position. Keep in mind, though, if a light duty job already exists, reassignment is required as a reasonable accommodation. So it's important that you note that. Additionally, when considering whether or not you have to reserve light duty jobs for work-related injuries, the EEOC states that an employer may create a light duty job position solely for employees injured on the job. But if you have a job bank, that's a little bit of a different situation because an employer cannot reserve existing light duty jobs for on-the-job injuries, and you must consider reassignment of any disabled employee. So a lot of times employers do not want to have a job bank for that purpose. They just want to create the job for a workers' comp accident. So keep that in mind, that if you have a job bank, you can't just hold those open just for workers' comp. That's a little bit of the concern.
Okay, so can you require that an employee come back 100% healed? No, you can't, because that goes against, really, under the ADA, that goes against the interactive process, right? You cannot say, you have to be 100% healed before you can come back. Where's the accommodation?
Yeah, that's
right.
Not the
Where's
standard.
The accommodation? So this is a question that we do get asked, occasionally, and it makes sense. I guess I could see a point where you want the employee to be 100% healed, and maybe for workers' compensation you do, but not, for the ADA, you have to go through that interactive process.
And most people are never 100% when they come in, so it's really just,
right.
It's really a difficult standard to reach anyway. So
right, and it's also, the same thing is true as if it's not a work comp injury. Somebody breaks their leg skiing. Right, or does something that has nothing to do with workers' compensation. You can't require that they be 100% healed.
With regard to light duty work restrictions, for workman's comp, you can offer light duty, and that's generally a money decision, but it's not a legal requirement. But we strongly recommend a return to work program. Having a return to work program generally gets the employees back to work quicker, and it gets the case closed sooner. So having someone at home, they're not going to really be enticed to come back to work, but if they're already working light duty, there's not necessarily a benefit to them to not return to work full duty. Many times there may be a little bit of a financial difference between the two, but it's really important for you to consider those return to work programs, and if you don't have one, working with your carrier to set one up. So we strongly recommend that.
And under the ADA, you're going to be looking at the essential functions. Can they do the essential functions of the job with or without a reasonable accommodation? Under the FMLA, can an employee decline a light duty position? They can, yes. They can, and then they can continue on with their FMLA leave. They may not get paid, right, because FMLA leave is unpaid. But that is something that they can do, and that's a separate analysis under the FMLA.
Right.
Okay, so you have an employee who is out of time. What do you do when they have been out on work comp? They've exhausted all of their FMLA, all of their 12 weeks. What do you do then? Well, first of all, you want to look at what other leave they have, whether your policy requires that it be used concurrently, and all of what your policies say, your handbooks say about that. It's important to understand, though, under that the ADA and the LAD still apply. The state and federal disability statutes still apply, and additional leave, even if they've exhausted all of their FMLA leave, additional unpaid leave can be considered a reasonable accommodation, and you have to go through that analysis as to, and I think we have an example here at the end.
Well, we talked about the fact of the indefinite leave and the fact that that's not necessarily a reasonable accommodation, so just keeping that in mind.
Yes, it doesn't have to be indefinite. There always does seem to be a question as to at what point it becomes indefinite, because we probably have seen this before, where they will be able to come back in 3 weeks, and then in 3 weeks, it'll take another 3 weeks, and then at what point does that become indefinite? And I know we have an example about to discuss that later on.
So when talking about benefits, just keep in mind the FMLA requires that the employers maintain group insurance benefits on the same basis. So the employee generally will have to be told at the same time that they're out on leave that here's your portion of the benefits, you're going to have to pay this on this date. So if they're not getting money through the employer, but they're getting it through workman's comp, they have to be told how much they have to pay towards their benefits to keep them active. But it's really important to keep in mind that that's a requirement. So you have to notify them of their obligation. It should be part of the packet when they're going out on FMLA leave, that you're notifying them of this information. Some of the best practices that we have are that, again, as I just said, you want to advise the employees of their rights under the ADA, FMLA, workers' comp. So especially if it's a workers' comp, and if your workers' comp, if your HR is not part of the person handling the workers' comp, you want to make sure there's a lot of communication. So you want to make sure that there's postings up, that it's listed, the information's in the employee handbooks, and just knowing that, especially for New Jersey, there's obviously other statutes that may apply when they're going out on workman's comp, or if they're how you're evaluating the ADA and the FMLA leave. You also want to make sure that you maintain communications with the employees when they're out on medical leave, but just make sure it's respectful. You want to make sure that it's not, if they do not want to have communication with you, you have to be respectful of that as well. Some employees, when they're out on leave, don't want to hear from you at all. They don't want you pestering them. So in that instance, you may want to send letters and do it that way. Other times, if the employee is okay with email communication or telephone communication, just make sure that all the information is actually in writing. But it all depends on how the employee wants to communicate with you and what they want you to communicate with them.
Right, and you also need to pay attention when you are preparing the initial FMLA paperwork. There's a line in there that says when they are supposed to contact you, and so you want to make sure that you are following that in terms of when they may return or that sort of thing. Some other best practices, really, it's a big part of this is just about communication within the organization. Oftentimes workers' compensation is handled by risk management. ADA, FMLA, those sort of leaves are handled by human resources, and risk management may not know that they need to get HR involved. And you really do need to have that communication going back and forth, because if the employee is going to be out, and if you want to designate that leave as FMLA, which you probably do because you want to be, working through those 12 weeks, paperwork has to be done. Right? The employee has to get notices. There have to be medical certifications. There are timeframes specifically set forth in the regulations that govern that, and when those have to go out, and how much time employees get to respond, and those sort of things. So it's important to keep communication between risk management and human resources open and active,
and also making sure that they communicate whatever information that's necessary to the workers' compensation carrier, so that they're aware of somewhat of what you're doing. Especially with regard to return to work or light duty positions. So if there's something available, how you can accommodate. So making sure that the HR person who may not be involved, so if making sure that the human resources is talking to risk management, who can relay the information to the carrier with regard to light duty positions and such.
Right. And one thing to keep in mind, particularly under the AD and FMLA, is who is communicating. We talked about communicating with the employee. The communication should not be by a direct supervisor.
No.
A direct supervisor should not be aware of the medical condition or anything related to that as it relates to the employee.
Correct.
It should be done by HR or risk management or a carrier or some sort of third-party TPA type thing.
Right.
And that's specifically required under those statutes. If you have any questions about those or suggestions, let us know. We do have some. We have walked through those, set up those processes with other clients. And it's important to keep medical files and personnel files separate, and they need to be kept under lock and key. So what would be included in a medical file? Anything related to a doctor, anything related to FMLA or, return to work paperwork, or, John Smith's going to be out today and is under my care, that sort of thing. Should not be in a personnel file, should be in a different file. So let's get to some examples.
Right.
Go ahead, Joe.
So in this one, we have Joe Carpenter calls out of work for 3 days, and on the third day mentions he thinks he hurt his shoulder on the job. Now what? Well, the person he's probably telling that he was hurt his shoulder is the HR person, and this may, as we say, be different from the risk manager. So it's important to keep in mind that you notify the risk manager immediately and then notify the workers' compensation carrier, because it's important that they can start the investigation. And given that it's 3 days, you want to make sure you're obviously behind the ball with regard to the reporting of the injury. So it's something you want to be able to start the investigation right away. It's also important to note that when someone's calling out, they don't have to give you a ton of information, but you do want to inquire as to why they're calling out. Someone calling out because they have a stomach bug or the flu is different from someone calling out and saying, my back really is hurting me and I'm going to be out. At that point, you may want to consider asking if there was an injury, especially what you may want to do is talk to their manager, see if anything happened the last few days of work, and start your investigation when you know that they're out of work, and it's depending upon what the injury is. So the HR should keep that in mind when they're getting these messages that someone is unable to come to work. So the more information that the employee gives you, the better. But again, you're not entitled to a ton of information at that point.
Okay. So then another area that we see a lot of is Bob. Bob here, he's exhausted all of his FMLA leave. He's got no other time. He used all of his PTO, all of his vacation, and his doctor says that he is continuing treatment and cannot yet return to full duty. Now, let's assume for a second that you cannot make an accommodation as far as the duties are concerned. So he's still going to be out. The question is, do you have to provide him with additional leave? And the answer to that is maybe or probably. It's going to depend. Certainly, as we said before, additional unpaid leave can be a accommodation, a reasonable accommodation under the state and federal statutes. The question becomes, what's reasonable, and when does it become indefinite? So, we talked before about an employee they've been out on leave for 12 weeks. Let's say Bob comes back to you and Bob's doctor says he's almost there, he needs another week. Is that going to be reasonable? I would say yes, give him the other week, right? Because it's he's already been out. You've dealt with the absence for that long already. Another week is probably is not that long. If he comes and he says it's going to be another 12 weeks, well, that's not reasonable.
No.
Right? So that would be a request that you probably would be able to deny, but you would still need to go through the interactive process. The kind of gray area is when he doesn't give you anything definitive. he says it's going to be 3 weeks, and then in 3 weeks it's going to be another 3 weeks. At what point does that become indefinite?
Now, for New Jersey workman's comp accidents, it's a little bit easier because we have the doctors and we're controlling the treatment. So you're able to communicate with the doctors and get a little bit more of a definitive answer. But again, when it's not a workers' comp accident, that's usually when you run into the problems where the doctors are, it could be a PCP or it could be a doctor who's not really communicating enough to you. You can ask for more information, more of a definitive response.
Yes, you can.
So making sure that communication with the doctor, that's important. That's a step that you need to consider as part of your interactive process.
Right, and just from a straight FMLA standpoint, even if you aren't in communication with the doctor, you can ask the employee to provide you with more information from their doctor.
Correct.
You can, and you can ask, okay, doc, why were you wrong the first time? What has changed? Has something changed that he needs additional time? Get more definitive information from them. And with that information, then you can make a determination as to whether it really is an indefinite leave or not. Now, another question that we are asked oftentimes is about an employee who doesn't want to cooperate or doesn't want to provide the information. And this is probably more in terms of the FMLA side as opposed to the work comp side, because...
But even if it's a denied work comp claim, you still get that type of situation.
Exactly, yeah. So. Yeah, so what do you do with an employee who refuses to give you information? If they refuse to give you information, they have to participate in the interactive process as well. And they cannot claim that you are interfering with their FMLA rights if they won't provide you with the information you need as far as leave, or they can't say that you're not providing them with a reasonable accommodation if you haven't provided them information with what that is, what you're proposing, and if the employee hasn't participated in that interactive process.
Right, and that's why making sure one of the most important things is sending the written documentation and then just backing up all communication in writing. This way, everything is documented, and you can show if someone ends up filing a claim, you can say, well, here's the documentation that shows that we participated in the interactive process and there was no response. Here's what we did. So making sure that any communication is always backed up in writing. So that's really an important key.
Right. So if the FMLA is not coming into play, if they haven't provided the information under the FMLA, then it's going to just go to their to your company's attendance policies. Right. And, employees want the benefit of the FMLA because they want that job guarantee, guarantee to get into to come back to the same position, and they want their benefits, their health benefits paid. So, if they are not if they are not providing information required by the FMLA, there are specific regulations that say how much time they have and what you do if they don't provide it. As far as the ADA is concerned, if they're not participating in the interactive process, then that's something else that, I would talk with an attorney before you, decide to terminate their benefits or anything like that. But, they have to play along as well, and they have to provide the information, reasonable information requested. But as we said, that's less of an issue in New Jersey because there is so much control over the doctors, right?
Fortunately.
So we hope, so that's really what we have here.
We want to thank you for attending our webinar. And if you have any additional questions or if you want to learn more about the program and all other Weber Gallagher events, please go to www.wglaw.com/WG-University. And if you have any questions, feel free to reach out. Again, you can either reach out to Julia or myself. Our contact information is on the website. So if you need anything else, please just feel free to ask.
Thank you for listening.